intellectual property matters. So today she'll be talking about intellectual property, strategy, and management. She'll be talking for 10 minutes, and then she will be addressing the following questions during her presentation. What is intellectual property and IP strategy? Why can IP strategy be considered a part of IP protection? What is due diligence, and why is it important for businesses? Why is it important to evaluate a freedom to operate business? So with that, we'll be calling Rachel Sikwane up for her presentation. Thank you so much for joining us. Over to you, Rachel Sikwane. And we advise everyone to please put your cameras on so that we can see your beautiful faces. Thank you.
Thank you, Juliana. Appreciate the introduction.
Thank you.
Thank you, everybody, and welcome and good morning. I am Rachel Sikwane, as Juliana has mentioned, and I will actually be sharing this part of the presentation or topic with Armel. She will be speaking about intellectual property management. So I will just introduce the section and speak about IP, IP being intellectual property, IP strategy, and Armel will discuss IP management. There are a couple of questions that Juliana just mentioned now, some of which I will touch on during this presentation. Others I will touch on later on in the webinar when I speak about IP commercialization. They are probably more relevant for that topic for discussion. So IP strategy, what is it? Why is it important? And, you know, yeah, what is it and why is it important? I think it's important to start with the why. So why would you even come up with an IP strategy? Why is it important to do so before we discuss what it is? And what I usually do, and I'm not sure, I think it's Armel who's monitoring the slides. If you can move to the next one, which will basically show a graph. And it's a graph that I include in almost all my presentations, if not all of them. And this graph, yeah, it was the graph that you just missed. It's a graph that basically shows how IP has grown in the value of your S&P 500 companies. So you have your S&P 500 companies, their market value is reflected there from 1975 until 2020 is the latest stats. And you'll see that the light gray reflects the tangible assets, which are your buildings, your vehicles, your actual tangible assets. And intellectual property, which forms part of intangible assets, is reflected in the dark green. And you'll see that from the period of 1975 to 2020, there was literally an exponential growth in the value of IP within the S&P 500 companies, to the point that in 2020, the S&P 500 companies, which are basically your top companies in the world, 90% of their value sits in their intangible assets, in their intellectual property. And I think this is basically why it would be important, or why an IP strategy is important, because IP is important. And why is IP important? IP is important because it could potentially be the most valuable asset of your company, as reflected by this graph. If you think of, you know, for those of you on this webinar who run businesses and who own businesses, if you think of your company's tangible assets, basically, if you take that value and you multiply that by 10, that would be your company's actual value, potentially, and 90% of it would be IP. And so when we speak of an IP strategy and the importance of an IP strategy, I like to have this in mind, and I like to have clients have this in mind, because it's important to consider the fact that when you're talking about a strategy, you're potentially talking about the company's most valuable asset. And so if it is that critical to the company, then your IP strategy can't be separated from your business strategy. The two need to talk to each other. And so when it comes to things like, clients will come up to me and they'll ask, hey, help me come up with an IP strategy. What I ask them first is, what's your business strategy? Because your business strategy basically then needs to inform your IP strategy. What that means is where you file a trademark is informed by, your business strategy, which trademarks you file, whether or not you register a patent or you decide to keep your innovation or invention a secret and protect it as a trade secret, also informed by your business strategy. Which territories you choose to protect your intellectual property in, that too would be informed by your business strategy. Whether you conduct research and development within your organization, or if you choose to outsource it to a university, and things like who designs the packaging of your products. Is it going to be an outsourced function, or is it going to be an employee? Are you going to have an in-house design team that will design packaging for your products for you? Those are questions that would inform your IP strategy, but they themselves are informed by your business strategy. And so I think the whole point really was to just highlight that and say that, yes, an IP strategy, ultimately it helps you to decide what you're going to do with your IP in your business, and what you're going to protect and how you're going to protect it. But the point that I really wanted to just make at the outset of this webinar, and also at the outset of this section of the discussion, is that your IP management, your IP strategy, all of that needs to be informed by your business strategy. And the reason for that is because your IP could potentially become your business's most valuable asset. And as such, it needs to be treated with that in mind. Thank you very much. I think I'll hand over to Armel now, who will speak about IP management.
Okay. Thank you so much for that presentation. I'm sure that everyone listening has been able to learn something about intellectual property and strategy and management. Thank you so much, Rachel. And we know that you'll be coming back again later on. So to continue, we would be calling on the second panelist for today. The second panelist for today is Mrs. Armali Taylor Fowler. She's a partner at Cabinet T&F. Mrs. Armali Taylor Fowler is a partner at Cabinet T&F, firm specialized in intellectual property, located in Cameroon. She is an intellectual property strategist and an OAPI intellectual property attorney. She's a member of Global Intellectual Property Initiative and observer at AMO API, Association of OAPI IP Legal Representatives. She has been engaged on GIPSY mentorship and internship program for Nigeria. She's also engaged in intellectual property workshop and trainings. Her IP practice areas include trademark, patents, industrial design, and intellectual property strategy. Today, she will be talking about knowledge on intellectual property, trademark, and patent. And she will be addressing certain questions. What is patent and trademark? What are the advantages of trademarks and patents for businesses? So with that, I would like to welcome her to take over the session. You're welcome, Amarli. And please, I would like to just quickly ask everyone to kindly edit your name session, your name to carry your personal name on it. Thank you. Please, you can go ahead, Amarli.
Thank you, Juliana. Good morning, everyone, and thank you to joining us to this webinar in prelude of the celebration of African Intellectual Property, African Technology and Intellectual Property Day. I'm Eltara Fuda and specialize on IP strategy and management. I'm in charge of the presentation of patents and trademark. Okay, we have many companies in our society, and as Rachel previously mentioned, we observe that those companies, there are many companies who are specialized on the innovation and technology. And the companies specialized on innovation and technology are the ones who are mostly interested by patent, I mean. So, excuse me, I have a few problems to share my screen. Okay, let me get back. So I was trying to say that according to what said Rachel, we observe that intellectual property has a strategic place into the company, and with time, the place that intellectual property has to the company is much more important. So according to this slide, you can see that from the European Office of Intellectual Property, we were having a huge growing of registration of patents up to 2021. And those companies who are interested of the registration of patent are the company specialized on the innovation and technology. Why technology and innovation? You see that in order to create a new drugs or a new vaccination, like the vaccination of the COVID-19, the drugs of malaria here in Africa, researchers are taking a lot of time and are putting much more effort in order to develop it. So the aim of intellectual property is to ensure that those scientists can earn money from the intellectual property, and also to ensure that they can be recognized as the one who built the said intellectual property. So into the case of patent, we have to ask all the question, what is a patent? A patent is an exclusive right granted for any invention. The invention can be a product or a process that provides a new way of doing something or offer a new technical solution to a problem. As we can see on our screen, we have here a chair that helps to cure teeth, okay? So people, when you have the latest technology, it can be easier for you to manage the material that helps to cure the illness. So all these technology are putting in place so that people can be more comfortable into the society. In fact, intellectual property and patent as well are helping to improve lifestyle into the society. But when having the intellectual property, what is the main benefit of any company who has it? The main thing with patent is that patent gives rights to the company during a short period of 20 years. I know that most of you will say that 20 years is not enough, but 20 years can be enough if you use your patent strategically. It means that you can use your exclusive rights to see either you can license or you can pledge or measure your patent with other people. Your patent also gives you the right to exclude any person of using it without your authorization. when you have a new patent, there are many people who can be interested by it, but maybe the way they are selling the product into the market don't fit with the vision of your business. So you have the right to choose either you can work with them or not. And those who try to take your patent without your permission, you also have the different means that can help you to introduce an action, as we can see there, in front of OAPI or in front of court in order to enforce your rights. With your intellectual property, you can also have the possibility to choose how you can implement your business so that you can have the supplement incomes. Here we were talking about the fact that we can license the intellectual property asset, in this case, patent. But when you license it, you have to know that your patent, somebody else, when he uses it, he has to give you a reward according to the fact that he's using your patent. So he cannot use it for nothing. You'd also have to know that your patent protection also help you to ensure that if you have an employee or if you have a collaborator who works with you, he cannot take your patent without your permission. Because from time to time, it can appear that somebody was working with you, and when it's come to stop the relationship with the said company, he wants to take the patent and use it for himself as his own intellectual property asset. This one is not a right action, because if somebody wants to use your IP asset, you have to share, you have to give him the authorization. So in that case, you often have to ensure to have a non-disclosure agreement at the beginning of each relationship with your partner or collaborator. With your intellectual property, it's also possible for you to see how to have a strategic approach in order to develop your business with time. Because when you launch your company, you take in consideration that maybe you want to move to another country in 1 or 2 years. And when you want to enter into this new region, sometimes it makes sense to see if the patent that you want to use can be still interesting for your market, because we know that market has a lot of competitivity and people are creating things day after day. So you have to ensure that the new product, the new product can bring a new solution to the consumer into the market. So for that purpose, from time to time, your former patent can help you to see how to improve or develop a new one. Because that, it can be interesting for us to see, to have a look of some company who develop their business based on a good patent portfolio. So we have 3 examples of 3 companies. 2 of them are from Africa and 1 of them from Europe. We have Sasol. Sasol is a South African innovative chemical company, specialized also on energy. And since the establishment of this company, they are working on new technology solution in order to perform their product. Up to now, they have more than 500 registered patents. We also have Element 6. Element 6 is also a South African company. They are developing innovative diamond synthesis process. You know that when you build a new process in order to have a specific product or technology, you can choose to protect it as a patent. So Element 6 is also focused on the protection of the patent in South Africa and in many other countries over the world. For Amazon, we observe that Amazon is a chemical and energy-related technology. They are using it over the world, and actually they have something like more than 10,000 registered patents. This is the observation made in 2019 by Forbes. So all this show that patent is used by many people over the world, different way, but those people has to understand or put into the mind that patent does not protect their own company from the stealing of the innovation. Because people, when they file a patent, a trademark, or any other IP asset, they think that since they have already registered it, they already have the right and they can just close their hand and stay quiet because it's already protected. Here, they often use to say that OAPA has already protected my patent or trademark. But it's true that the office gives you the certificate, the means to show that you are the one who has the right to use your innovation, but you have to take some disposal so that the other people who can be interested by your innovation cannot use it for free. For that purpose, you have, as I said previously, to sign non-disclosure agreement. You also have to try to monitoring patent filing of your competitor, because your competitor can even choose to introduce something that is too close from your intellectual property. And since for litigation, we have a short delay to introduce into litigation matter. And even if you take time to resolve your litigation, from time to time, it can be more difficult for you. So when you monitor your patent filing, it is easy for you to be updated of what your competitors are doing. You also have to ensure to renew your patent. As you probably know, you have to maintain your rights each year of the anniversary of the registration of your patent. So this was the first part of our presentation. The second one was focused on trademark. When I talk about trademark, I'm sure that many of you know what I'm talking about, because you cannot have a company without having a trademark. Since trademark is any visible sign or audible sign attached to your product or your services, and what that helps to distinguish your product or services from those of the company. In that case, we took Squared Shoes. Squared Shoes is a young company established in Ivory Coast, okay? They are doing these nice shoes, but many people mostly know Nike, Adidas without any publicity of this company. And when it comes to buy a new pair of shoes, many people surely will choose to take Adidas one or Nike one because they feel that they are more comfortable, because it is a well-known, they are well-known company comparing to Squared. So at the end, trademark help you to identify who sell a specific product or services, and somehow it help you to make a choice by the time. So when we are talking about trademark, we have to know that trademark, as the other IP asset, also represent many advantage. Here we cannot give all the advantage of the benefit of the protection either for patent or trademark. So we choose few advantage of them, and we want to enlighten that when you have this trademark Square, when you protect it, you have right to use Square during 10 years, renewable indefinitely. Means that your trademark can live, you will just die and leave your trademark, let's say like that, because you just have to renew it, to ensure that you renew it regularly. But the most important thing for trademark is that you have monopoly, you have exclusivity to use your trademark when you have already registered it. But according to most of the intellectual property laws, you have to be the first to register your trademark. So trademark right bear to the first person who registered it. It means that if actually I'm using Cabinetian F trademark, okay, without registering it, any person is free to go and register it, especially in OAPA region, because here you cannot prove in front of OAPA that you are the owner of this trademark if you don't have any certificate or any proof of the application. With the trademark square, it is possible for you to also grant a license to anybody. So we have many companies in Africa, and most of them or some of them has a land in different other countries. I myself am working with some companies, some groups who are based maybe in Central of Africa or West on Africa, but they have legal representative or partner in English-speaking countries, North of Africa, and so on. So they always ensure that they protect the new trademark, and they do what we call inscription of the collaboration of the license agreement between the company and the other one, so that they can preserve their rights and interests during the business. This registration of the trademark also gives to Squared the right to defend the right, let me say that, in case of litigation. You have many options that you can introduce if you have a litigation. In order to keep your market share, you can introduce an opposition, claim of ownership, and so on. For me, I think that protection of trademark, patent, or any other IP asset go with enforcement, because protection and enforcement somehow is just the protection of your intellectual property assets. So here we took time to go through the survey that did by WIPO, okay? WIPO did a global intellectual property survey, and they show that in 2021, we were having 17.2 million of the registration of trademark. That is why at the beginning I said that most of the people there has a trademark if he has a business, because you cannot have a business without a trademark. So trademark is something that is really important for companies. We also want to enlighten some companies who are well known over the world according to the practices on the intellectual property, the importance that they give to intellectual property for the business. We talk about Uber. I discovered Uber in the West African region. Here they are not yet in Cameroon, but it is the largest taxi company. They are landed in many countries into the world, but they don't have any vehicle. They just work with the technology in order to develop their business. Airbnb, for example, is the biggest player in short-term property rental, but they don't have any accommodation into the world. So as you can see, intellectual property can have a very important role for the company. And this role is often much more important than the physical asset that a company can have. So globally, the benefit of IP protection for your business is competitivity, IP risk management. So you can increase your visibility, distinguish your product, avoid risk. We have already mentioned it, but as I told you, these advantages are not the only one. We have many other advantages. And before giving the floor to the other panelists, I want to mention that intellectual property is not important only for companies. Intellectual property is also important for the whole society, because it helps to improve the quality of our life. Through patent, especially, we know that when patents fall into the public domain, public can use it for free, and they can use it to develop their country or the quality of the life of the people. Thank you, Juliana.
Thank you so much, Armali, for that presentation, that beautiful and insightful presentation. And it's good to see that some of the examples that you gave are actually examples of companies that are situated in Africa. So it's good to know that there's also innovation going on here, and it's good to see the data. Thank you so much, Amarni, for that presentation. So with that, we'll be moving to the presentation from the third panelist. Our third panelist is Mrs. Sarah Noko Anku. She's a senior partner at Anku at Law, Ghana. Mrs. Sarah Noko Anku is a legal practitioner and intellectual property attorney and consultant. Anku at Law, Ghana and Nigeria. She's a member of the Ghana National Folklore Board, the Intellectual Property Committee of the Ghana Food and Drug Authority, and the International Advisory Council, and an associate partner at AFTA Policy Network, APN. She's the first president and a director of the Intellectual Property Network Ghana. She's also an adjunct lecturer at Minfield Intellectual Property Program at Kwame Nkrumah University of Science and Technology, KNUST, formerly a state attorney at the Ghana Industrial Property Office, Registrar General's Department. She holds a master's degree in intellectual property, Zimbabwe, LLM and her LLB at Ghana, MSc London, BSc Ghana. Her IP practice areas include patent, trademark, industrial design, copyright, and traditional knowledge. She has particular interest in intellectual property as relates to trade under the African Continental Free Trade Area, AfTA, and IP asset management in general. Her focus for her presentation today will be copyright and industrial design. She has about 20 minutes and she'll be addressing the following questions. What is copyright? What is industrial design? Benefits of copyright and industrial design for companies? In which situation does ownership of copyright belong to the company? Sorry, in what situation does the ownership of copyright belong to a company, and how to protect copyright online? So with that, I would like us to be expectant and to listen carefully to her presentation. You're welcome. Please, you can take the floor. Mrs. Sarah Noko Anku. Thank you.
Thank you very much, Juliana.
Thank you.
Good morning, everyone. Just a quick question before I continue. Am I able to control the screen from here, or Mel will be controlling it from your end?
Yes, you can.
Okay. Yes, I don't seem to be able to shift it. Anyway, good morning once again. So my focus, the topic is focused on Ghana, but I'll speak to it as broadly as possible. How do I? No, I'm sorry, I'm unable to shift the slides. I'm unable to move the slides.
Okay,
if you want to do that for me, because I'm unable to shift it.
Yeah.
Otherwise, I can share my slides from here, because I can't seem to, yeah. Okay. So basically, in Ghana, when we talk about copyrightable works, we refer to your literary works, artistic works, musical works, sound recording, audiovisual works, choreographic works, derivative works, and your computer software and programs. For you to obtain a copyright in these works, the works must be original and must be fixed in a definite medium. If you want to register the copyrightable work in Ghana, you have to be a citizen of Ghana or resident in Ghana, or you should have published the work in Ghana, or if it was published outside subsequently publish it in Ghana within 30 days. However, Ghana is obligated under certain international treaties, including the Berne Convention, to register certain copyrightable works. So we are bound by that, and we register almost all copyrightable works that are captured in our law. That's the literary works, as I mentioned earlier on. Now, the protection of these works, these copyrightable works, are not affected by the quality of the work or the purpose for which the author developed or created the work, or the manner or the form in which it is expressed. So long as you have this copyrightable work and you have it expressed in a medium, it will qualify for copyright protection in Ghana. Remember, intellectual property is a subject of law, and the domestic laws of the various countries govern the rights that you obtain or whether the works are protected in the first place. In Ghana, we do not protect ideas, concepts, procedures, methods. Can we remain on that slide, please? Yes, no, the previous one. Previous, yes, please, yes. So we don't, as I mentioned, we don't protect ideas, concepts, procedures, methods. And we have, the courts have actually made emphatic pronouncements on these. And one interesting one is a case on the Pearson Education versus Morgan Ajay. Morgan Ajay wrote a book that was being used by the schools in Ghana, secondary schools in Ghana. And I think the Pearson Education came up with a summary version of that book. And because of that, the Morgan Ajay lost a lot of money because the students preferred the summary of it. One would have thought that that summary would have been an infringement on Morgan's rights, but somehow the Supreme Court held that that summary was a summary of the plots in the book, and the plots were subject to ideas. So were just ideas. So those ideas were not captured under copyright. So when you are dealing with copyright issues in Ghana, you need to be quite mindful of what rights you are seeking, whether the works are covered by the Copyright Act of Ghana, and how the judges are in the long run going to interpret that particular right. Now, registration of copyright is not mandatory in Ghana, but then it is very advisable to register your copyrights because of enforcement issues. I have a few clients who are still having some issues with enforcement of their rights because they did not register their copyrightable works. Because if you don't register the copyrightable works, when there is an issue, you then have to prove that you actually created the work before you can enforce your rights. And that sometimes creates a lot of problems for clients. On the other hand, when you take industrial designs must be registered for you to have protection. And usually it deals with the aesthetic value of your goods. So we are talking about lines, colors, three-dimensional form of materials, even textile designs are protected as industrial designs in Ghana. And these industrial designs must have a special appearance to the product or industry or handicraft, and should serve as a pattern for a product of industry or handicraft. So we are basically talking about the aesthetic value of the product. And this work will be registrable in Ghana if the work is new. That is, it differs from known designs or combination of known design features. And this must not have been disclosed to the public, or even if it were disclosed to the public, it should have been at most 12 months before you attempt to make that registration. Next slide, please. Now we have a few laws governing industrial designs and copyright in Ghana. The main act in Ghana, of course, is our Act 690 as amended, and we have the airline governing it. We are also parties to certain international treaties, the Berne Convention, the Paris Convention, the WIPO treaties, that's the WIPO Copyright Treaty, the WIPO Performance and Phonographs Treaty, etc. So as an international business wanting to enter Ghana, you should know that if your country is party to any of these international treaties, Ghana will be obligated to recognize your rights when you take the necessary steps and you conform to the local laws of Ghana. With industrial designs, we have our Industrial Designs Act of 2003, which is Act 660. And then we have textile designs regulations. We do not have any industrial designs regulations, so it makes registration of industrial designs in Ghana very difficult. So usually what I advise my clients to do is that I apply through a repo, which also does registration of industrial designs for Ghana, for and on behalf of Ghana. So that's what I usually do for my clients. But when it comes to the textile designs, we can register it directly through the Ghana IP office here in Accra. We also have parties to certain international treaties like the Hague, and of course, we are party to the Aripo-Lusaka Agreement and TRIPS, etc. Next slide, please. What are the rights that are conferred to you? I mentioned that copyright is automatic protection, but when you register it, you have the advantage of easier enforcement of your rights. The rights that you have are the economic rights, and of course, the moral rights. This is a general principle in copyright law. It's the same everywhere, so long as the states are parties to the Berne Convention. You have your copyright, you have your economic rights, and then you have your moral rights. With the economic rights, we're talking about reproduction of the work in any form, translation, adaptation, arrangement, or any other transformation of the work, public performance, broadcasting, communication of the work to the public, distribution of to the public of the original copies, or the originals, or the copies of the work by way of first sale or other first transfer of ownership, and the commercial rental to the public of the originals or the copies of the work. When it comes to the moral rights, of course, you have a right to claim authorship, and the right, of course, in particular, to demand that your name or the pseudonym is mentioned whenever any of the economic rights are being performed. The economic rights of the author are being performed. So you have a case where an international organization takes a music of someone here in Ghana. The person had not actually registered the music, but then because there's automatic protection, the person has a right to his music, and the international organization ended up using the music without acknowledging the owner, the copyright owner, and also without taking a license. So that particular case is presently before the court, and we are waiting to see what the outcome will be like. When it comes to employed authors, this is quite an interesting provision where you create a work. Any of the works that I mentioned earlier, the literary, the music, the sound recording, and so on and so forth, if you create these works in the course of your employment, the law says that the work will automatically belong to the employer. And if you're commissioned to do any of such work, the work will automatically also belong to the person who commissioned you to do the work. This, unless that employer is governed by a contract which has contrary provisions to this particular law. It happens sometimes. I did a policy, an IP policy for a university in Ghana, and that particular university opted to have a contract contrary to this provision, such that when you develop any copyrightable work in that particular university, the work will automatically belong to you, even if you are an employee of that particular university. And I found that to be quite interesting. The courts have also pronounced on this particular employee-employer relationship. In the case of Bosompem versus the TV3, there was this program that was developed by Bosompem and his team, has to do with the boy and the Shushan boy and the barber. And that particular show, it was a TV show, was later on purchased or was in an amalgamation, company amalgamation process, the company mergers and amalgamations process. The TV3 purchased this from the Ghana Film Authority, and Bosompem and his colleague claimed that the rights belong to them. The rights in that particular TV show belong to them. But the courts held that Bosompem was an employee of the Ghana Film Authority at that time. So the work that was developed belonged to the Ghana Film Authority. So if there was a merger, then it automatically transferred to TV3. Meanwhile, the other party, the second plaintiff, was found not to be an employee of the Ghana Film Authority. So it was held that he still had rights in the works that was being claimed by TV3 and had to be compensated for the use of the work without his consent. Now, when it comes to industrial designs, of course, the exploitation of the work requires the consent of the owner. And this means that if you want to make, sell, import, or otherwise distribute for commercial purposes, articles bearing or embodying a design, which is a copy or substantially a copy. So it need not be the actual copy. If it's substantially a copy of that design, then you need a consent of the owner of the right, and the consent usually comes in the form of a license. Without that, you will infringe on the rights of the design owner. So as a company, if you own certain designs, you may have to take the necessary steps to have the designs registered, because without registration, the industrial designs will fall into the public domain and you will not be able to enforce those rights. The rights also include the rights to institute a court proceeding against the infringers who perform these acts against your work. So that also secures your rights as a business so that you can maximize the profitability of your industrial designs. Next slide, please. Can I have the next slide, please? Thank you very much. Now, the duration of protection in Ghana is for an individual, it is your lifetime plus 70 years after your death. And if it is a joint authored work, then it is 70 years after the last surviving author's death. When it comes to bodies, corporate, anonymous works, audiovisual works, it is 70 years after the work has been made or first published, whichever one is latter. When it comes to sound recordings, it's still 70 years after the work was made or after the publication or when the work was fixed. We also protect in Ghana, we protect folklore as copyright, and the duration of protection is in perpetuity. Moral rights, as I mentioned earlier on, the right to claim authorship of the work is also in perpetuity. So your economic rights could last, but then the moral rights, the right to be named as the person who created the work, lasts in perpetuity. Performance rights also last 70 years. But it lasts 70 years from the day the performance was fixed or when the performance took place. You notice that the years remain constant, 70 years, but when it comes to broadcasting organizations, their rights last for only 40 years from the date the broadcast was made or the signal was made. On the other hand, when it comes to industrial designs, the duration for protection is 5 years. But this 5 years could be renewed for 2 consecutive 5 years, making a total of 15 years if the business so wishes. So if you feel that your industrial design is performing very well, you could take advantage of the whole 15 years. But if you feel you want to change along the way, yes, you can change along the way, because you will have to be maintaining these industrial designs on the register of the registrar of industrial designs, and that includes paying fees. So it's actually a business decision that you have to take. Next slide, please. Yes, when it comes to monetizing this copyright and industrial designs, earlier presenters have mentioned the licensing. You also have assignments, self-exploitation, joint ventures, donations. So licensing is when you still have control of your work. You don't actually dispose or give out all your rights to the work, but then you control the work and somebody allow others to use that particular design or that particular copyrightable work. So if you have a music, you want to just license it out to an advertising company. The advertising company could use the music for a particular period. You can also license to another party and so on and so forth. You still have control, you still have ownership of that particular copyrightable work. And that also applies to your industrial design. You can license to other companies to use that particular design for other products or your own products. Then you have assignment. In this case, you just assign all your rights to that the other party, and you don't have any control over it anymore. You can sell off your industrial design, or you can actually just keep licensing, and it's a form of revenue. You keep raking in some monies into the business. Then self-exploitation. You have your own industrial design, you have your own copyrighted work, and you just want to exploit it. We developed this, we created this book on monetization where, that's my firm. We giving details as to step-by-step ways of monetizing your work. And we are exploiting it ourselves. We can choose to give out to distributors to do that. It's actually a business decision. So I heard our earlier presenter mention that your business strategy your IP strategy should follow your business strategy. So if at the moment my business strategy is to self-exploit this particular book, then so will it be. If I want to give it out to other distributors to do that for me, it is a business decision that we have to make. We also have joint ventures. You can bring in other parties, investors, to help you to monetize the industrial design or the copyright work. You can also choose to give it out as a donation. It is your right. If you own it, it's a property. Just as you own other physical properties that you can choose to actually donate. I can choose to donate my car to somebody, so I can choose to donate this my IP right to other parties. Next slide, please. Next slide, please. Thank you. Now, having a right without being able to enforce the right will have no meaning. The right will have no value. Can I move back to the enforcement, please? Enforcement, please. Back. Can you go back 2 slides back? Another? Yes, thank you very much. So you need, no. Come back to the, yes, enforcement. Thank you very much, Mel. So if you have a right and you cannot enforce a right, then the right will have no value. As a business, you should be, the main reason I think will be to be able to enforce your IPRs, because if you don't have IPRs and you still own your work anyway, that you are not secure. Anybody at all can infringe on your rights and you will not be able to do much about it. So the whole essence of this IPR for a business is for you to be able to secure your assets, your intangible assets, your intellectual property assets. So in Ghana, we have various forms of enforcement measures. We have the administrative and also the border measures. So with administrative, when you take the Ghana Industrial Property Office, when it comes to industrial designs, you can oppose the registration of an industrial design. So if somebody steals or takes your industrial design and rushes to the Registrar General to register your industrial design, there's a stage where the design is published, and where the design is published, you can then take steps to oppose the registration of the industrial design in the first place. Also, border measures. Border measures includes the Customs, Excise, and Preventive Service of the Ghana Revenue Authority of Ghana. In this case, if you are aware that there are some infringing materials coming in, if you take your copyrighted works, if you know there are infringing materials or copyrighted works coming in, you will take steps and get the steps officials to seize or to detain the works, the infringing materials at the borders, so that they do not even enter the channels of trade. When it comes to the civil measures, of course, we have the alternative dispute resolution. A typical example is mediation at the Copyright Office. So when you have a dispute and you do not want to go through the litigation process, especially when it comes to copyright works, the copyright administrator is also a mediator. So she can sit in and mediate the whole process for you. And if you are not able to resolve the dispute, then of course you can proceed to the courts for litigation. And then of course the litigation is also available at the courts for you, at the High Court of Ghana. Now the possible remedies include injunction. In the case of Charles Uche Aka and another Nkwesi Chum and Multimedia, the court held that the injunction relief is automatic. The moment the court decides that there has been an infringement, the law requires that there should be an injunction on the infringer to desist from doing further damage to the owner of the rights. Of course, you can also get damages. There could be seizure and disposal of the infringing materials. The infringer could be asked to account for profits and also pay compensation. And then one unique aspect of it, of our enforcement measure, is the disclosure in respect of the infringement. Where you have maybe some competitors bringing in your infringing materials and you are not sure where they are sourcing those infringing materials from, you can request that this particular infringer discloses where he or she obtains, or the company obtains, these infringing materials from, and then you can deal with all the infringers, well, a number of them at a go. So that's quite unique in the Ghana law. And then also in the Ghana law, we have the criminal enforcement aspect of it, and that involves criminal prosecution. The police, CID, Criminal Investigation Department of the Police Force, have authority to prosecute these infringing copyright infringement or intellectual property generally, intellectual property infringement, that includes industrial design infringement. And they also have the right to raid markets. So if you are aware that there are infringing materials on the market, you can take steps, you can involve the police and they will raid the markets, arrest those who are infringing your product, and then start the criminal prosecution against them. And then one other unique provision in our copyright law is that the infringer is supposed to compensate the owner of the copyright work. Next slide, please. Yes, thank you very much. So I thought I should mention some of the institutions, relevant institutions when it comes to copyright and also the industrial design. So businesses are aware of what to do when they enter Ghana. So in Ghana, we have the Ghana Industrial Property Office, which is a an office under the Ministry of Justice, and they are responsible for the registration of industrial designs. When it comes to copyright, the Copyright Office is also responsible, which is also under the Ministry of Justice, is also responsible for the registration of copyrightable works. As I said, it is not mandatory to register your copyrightable works, but it is in your interest to register it so that it will facilitate enforcement. Even when you're going to court, or even when you go to the police station to report any infringement, the first thing they ask for is your certificate of registration. So if you don't have that, then you have to now go through the headache of proving that you actually own this particular copyrighted work or even the industrial design. Now, the Customs Excise and Preventive Service of the Ghana Revenue Authority, of course, for the border measures to prevent the goods, the infringing materials from entering the channels of trade. Of course, the police, Ghana Police Service, can come to your aid when the goods are already on the market. And then, of course, the courts of Ghana, they also come in when you have to go through the litigation process. We also have collective management organizations in Ghana. We have GAMRO for musicians to help you with your royalties, collection of your royalties from the users of your copyrighted works. We also have Copy Ghana for Reprographic Society and then ASOC for Audiovisual Society. So all these facilities are available in Ghana for owners of copyrighted works and for owners of copyrighted work, and of course the industrial designs as well. Now, key areas, importantly, you realize I kept mentioning ownership, right? Because if you cannot prove ownership of your rights, then you would have a challenge enforcing your rights. So you must take steps to have your industrial designs registered, number one. Number two, copyright. Yes, you can have your rights, but then it is in your interest to have it registered so that you have the certificate in order to facilitate the enforcement of your rights. Be mindful of contracts and agreements, especially your license agreements. I have found some onerous agreements from clients that I feel very sympathetic towards them, because they end up more or less giving out their rights for peanuts because they did not engage the services of professionals in signing those contracts and agreements. So be mindful of the contracts as a business that you engage, you sign up with your potential investors or partners. Now you have to be vigilant in enforcing your rights. Can I remain on that slide, please? Thank you very much. So vigilant, you have to be vigilant in policing your right, because just like any other tangible right, you have to take steps to protect your rights, your assets, and get the necessary authorities involved to, to prevent others from infringing on your rights. And that includes the online. One interesting thing about online copyright is that the laws apply to the copyrighted works online. The laws of Ghana applies to that. What I've come to realize is that the online copyrighted works are easier to enforce in Ghana. That is my view, my personal observation. It is easier in the sense that it is easier to prove that there is an infringement on your work, because all you have to is to just show to the relevant authorities. If you are going to court, you can just prove that the works are being exploited online. If you are using the police to help you to stop the infringement, you also have these online infringements as proof of your other parties infringing on your work. So it's a bit, for me, I think it is quite easier to enforce your online copyrighted works. But first of all, please, it's always important to have it registered, then it's easier to enforce. Now you have to enforce your rights to deter potential clients. I've also noticed that there are certain clients who will just say, oh, it's just a minor infringement, let me let it go. But so long as you keep letting infringers go, then others will just keep infringing on your rights. In the long run, you lose, if you don't take care, you lose a huge chunk of your market share. So I always advise that when you find an infringer, please take steps so that when you do that, it will deter others from infringing on your rights. And please seek professional assistance. This is a technical area, and you may, if someone is not really familiar with intellectual property law and practice, that person may not give you the needed assistance that you require at a given time. It is very important to seek professional assistance to help your work. It may cost you a little money, but in the long run, it is more beneficial. Next slide, please. Yes, so thank you very much. I highly recommend, again, if you want to commercialize your copyright and industrial designs in Ghana and to effectively enforce your rights, please do not traverse the corridors of intellectual property rights in Ghana alone. Seek professional assistance from practicing lawyers who have specialized in the field of intellectual property rights. For my firm, at Law, what we do is we help you with your registration through the drafting of your IP commercialization agreement to facilitate liquidation. And assist with the enforcement of your rights within Ghana. So thank you very much. Cabinet TF, I really appreciate this opportunity. You are doing very well. And I hope we'll get this opportunity again to educate a lot more people in this area. Thank you very much all for this opportunity. Thank you.
Thank you so much, Mrs. Sarah, for that presentation. We've actually learned a lot, and I think it's very good that you also spoke about protecting your work online, because now we know that lots of things that are actually done online. So it's good that people know that you have to be the police of your work and you have to monitor it online. Thank you so much for that presentation. And then we'll be going to our fourth panelist for today, Dr. McLean Sibanda. He's a director of Vegan Global Limited, South Africa. Dr. McLean Sibanda, Managing Director of Vegan Global Limited and founder of Megeto's Legacy Catalyst Limited. He is a respected intellectual property, innovation and entrepreneurship expert with excellent understanding of different ecosystems in Africa. He is an engineer, an attorney of the High Court of South Africa, and a registered South African patent attorney. He consulted for Southern African Development Community, African Union, World Intellectual Property Organization, Government of Eswatini, South Africa and Tanzania, and UN Economic Commission for Africa. He is a visiting lecturer at Africa University, Mutare, Zimbabwe, where he lectures on innovation and entrepreneurship to masters in intellectual property management studies, I think. He has published 2 books, Nuts and Bolts, Strengthening Africa's Innovation and Entrepreneurship Ecosystem, January 2021, Tracy McDonald Publishers and Footprints, Laying the Paths, Intellectual Property for Innovation and Economic Development, in October 2021, Tracy McDonald Publishers. Today he'll be talking about knowledge of intellectual property and how it is managed in South African universities. He has 15 minutes to discuss this, and while he will be discussing this, he will be touching the following questions. Is there a regulatory framework? Are there research working groups? Is the contribution for students taken into account? Is there a partnership between industry and research? Is there collaboration between the research community and the National Industrial Property Administration? How does the university market its intellectual property rights? How are the revenues shared? And so with that, I'll be calling forth Dr. McLean Sibanda. Thank you so much for joining us.
Thank you very much, Juliana. I'm not sure whether Amel is on the line. I thought that we were going to do, I think, a Q&A with Amel. If not, then perhaps let me address the few questions that I have been asked to deal with.
Yes, I'm there. Good morning, Dr. McLean.
Yes, good morning. So perhaps let me just give a high-level overview or introduction, and then I think we can do a quick Q&A. I think one of the critical things, we've had, I think, great presentations, this morning on various aspects of intellectual property. And I always say that anybody that ignores intellectual property ignores it at their own peril, because intellectual property is everywhere. It's around us. If you go to a shop, you're confronted with trademarks every day. If you go to a coffee shop, you are also confronted at times with patents in terms of the lead for that coffee, takeaway coffee that you buy. Some of them have got inventions that are protected by patents. If you go to a pharmacy to buy deodorant or roll-on, you're confronted with designs in respect of the roll-ons, the different roll-ons. Your phones, you're confronted in essence with trademarks. If it's an iPhone or a Samsung, or you're confronted with patents in respect of the processors inside, or even design registrations in terms of the look and feel, and naturally copyright regarding the software and the code that runs on those devices. But what we know as well is that inventions arise from extensive research. And one of the things that we see is that Africa still produces less than 1% of global patent output, which is quite low. But also when we look in terms of the amount of money that we spend on research and development, whereas the big countries like Japan, China, Switzerland, America, and so forth spend more than 2% of their GDP on R&D. None of the African countries spend anything close to 1% of GDP. And that is a challenge. So if we are going to compete based on inventions, based on intellectual property, it's quite critical that we increase the extent of research and development that is undertaken not only at our universities and research institutions, but generally in companies throughout the continent. And that brings me to the first part of perhaps a question around how do universities manage intellectual property? And the response is in essence that it is varied. It depends where you are. If you are sitting in South Africa like I am today, then there is a legislation that governs how intellectual property is managed at universities. And that is the Intellectual Property Rights from Publicly Financed and Publicly Financed Research and Development Act of 2008. In terms of that particular legislation, it states that any intellectual property developed at universities or research councils or research institutions is owned by the university or by the research institution. There's an assumption that that intellectual property arises from R&D that is funded by the state, and one has got to prove otherwise that it is not funded by the state. In those particular cases, then the intellectual property is deemed to be funded at full cost, and therefore whoever is funding that research owns the intellectual property. So that's the first thing that we see in South Africa. Now, the South African example also comes from perhaps general practice in the US under what is called the Bayh-Dole Act, which also stipulates that any federally funded research and development, the IP that arises therefrom will be owned by the institution. Now, at times ownership is seen as being important, but I would like to submit this afternoon, that access is perhaps much more important. So whereas the universities would own the intellectual property arising from that research, they can then license it out, which is almost like giving rent, getting other people to lease the rights to that intellectual property, and therefore access is actually given. So that's the general case. But now the question that one often asks then is, okay, if the university owns the intellectual property, what happens to the inventors, the people that came up with the invention, people that came up with the intellectual property within the context of South Africa and also the US, and we're seeing that more and more in other countries, is that then the researchers or the inventors have got a right to benefit share, which means that when it is commercialized and there's revenues that come in, then the researchers are entitled to a percentage of the revenues that are received by the university. And in that particular case, in the case of South Africa, the law stipulates 30% as a minimum must accrue to the researchers, and then the balance is shared amongst the university within the central port of the university and also the department, that funded, research within the university. Now, I think in terms of commercialization, which is licensing, it is therefore very important that the university undertakes research that is relevant to society. And in that particular regard, if the university is doing research that is relevant to society, it then becomes easy to commercialize that intellectual property or find access to the market for that particular intellectual property. So let me perhaps pause there and turn it back to Adele to see whether she wants to pose any one or two follow-up questions. Yeah.
Hello, please kindly mute yourself. Yes. So if you have a question for our panelists, please just raise your hand up and then we will call you for you to ask your question. So does anyone here have a question for Dr. McLean? If you have a question, please just raise your hand up and you'll be called, or you can type your question in the chat box.
So I guess whilst they're thinking, the other question that is arisen is one of students who owns the intellectual property that is developed by students whilst studying. And here we see that some of the universities take a view that students make use of the infrastructure of the university. They get supervised by lecturers or professors from the university. And often the students are working on projects that are already funded by the state or funded by a funder. And in that particular case, if that is indeed the case, then the ownership of the intellectual property is governed by who funded. And in general, I think we see Stellenbosch University, for example, is quite clear that all IP developed by students is owned by the university. But there's also an argument that one can make and say, well, I might be studying at the university and I'm not utilizing the infrastructure of the university, and I come up with inventions outside of the university. I should be able to own the IP. And I think if one can argue successfully in that regard, particularly in the case of undergraduate students, for example, that pay for fees and do minimal research within the university, then I would say that the student would own the IP, and it would be in the student's best interest to work with the technology transfer office of the university in order to commercialize their intellectual property. So let me, stop, there, and we can take it forward if there are any questions.
Okay, so please, we're still waiting for your questions in the chat box. So we'll take 3 questions, and then for any other person who has a question, you can just send your question to Cabinet TNF. So the questions that we had here before, I'm sure that he has already touched them, but if you have another question, please feel free to raise your hand up, or you can put them in the chat box. Okay, so Shukurat is raising her hand up. Please, you can unmute yourself and ask the question. Shukurat Amusa. Thank you.
Hello, good morning.
Good morning.
Can you hear me?
Yes, we can. Yes.
Okay. So my question is with regards to the issue of employer, employee, and ownership. Because in a case whereby, yes, you are an employee, but what you are doing or what you've created doesn't have any relation with what you do at your workplace, who owns the IP? So I think we need to like kind of find a way to go around this, because sometimes employers can be selfish. They know they don't own the right, but because the law says whatever an employee does belongs to the employer, then they automatically want to have a right to that IP. So I would like you to address this question. Thank you.
So, Shukarat, very important, question that you ask. One of the things that we find in law is something called cause and scope. And when it comes to inventions, the law generally defers to what is called cause and scope. It says cause and scope is how you are employed and when you are employed. So if you are employed as a researcher, you're expected to research. So yes, it's cause and scope. And then cause of employment means whilst you're employed, it's regardless of how you are employed. And we find that a lot, particularly in respect of copyright. Copyright is very clear, the laws around copyright, that any IP that is generated, copyright generated during the course of employment would belong to the employer. So it's regardless of how you are employed. You might be employed as a typist or as an analyst in one department, but whatever you produce, of copyrightable nature belongs to the employee. Now, I think there is actually, a case of, for example, if someone is employed in the printing room, for example, to bind together documents, and they come up with an invention that is unrelated to the business of where they're employed, that invention would typically fall outside, because we go back to cause and scope of employment, how and when they were employed. And I think the when they were employed, they would tick the box, but then the how they were employed, they'll be able to argue convincingly that they were not employed to invent, and there was no expectation in their case to invent. And I guess, the typical case, classical case that we're going through currently in South Africa is one of please call me, because Mr. Mukate argues the inventor that he was not employed necessarily to invent, and therefore he owned, and therefore he disclosed to Vodacom, and there was an agreement that was entered into effect as to how to take that forward. I'm not sure whether I've answered your question, Amusa.
Yes, sir, you did, sir. Because I have also come across some case studies whereby some court says you own the IP as an employee, but other court says you own the IP as an employer. That's not to be sure. Thank you, sir. Okay.
So there's a second question here from Likan on the chart. It says, please, at what level should we consider IP valuation in infringement claims? And then the second part is, don't you think as we protect IP, the IP valuation is critical in IP commercialization? Let me start backwards. I think IP valuation is critical, but you can only value something that has got, there's got to be some value. So there's a lot of intellectual property that is, identified and perhaps protected as by way of patents, but is never commercialized. In that particular case, typically your valuation of that IP would be on the basis of either a cost method, how much did you spend to come up with that IP, or secondly, what is called comparatives, the IP of a similar nature out there in the marketplace, how much does it fetch? And then thirdly, there is obviously then the on the basis of royalties or the income, projected income that would come. Now, I would not worry a lot about valuation up until there is a value that can be attached to that intellectual property. which means that there must be a willing buyer. There must be somebody perhaps that is prepared to pay or get a license, for that particular IP. And one has got to prove that even if there's no one that is prepared to do that, there is sufficient market traction for the product or service that arises out of that particular intellectual property. And it's at that particular point. So from an infringement point of view, valuation becomes important in computing what one would call damages or royalties that otherwise would be payable in lieu of damages. I hope that answers your question, Likan.
Thank you very much, Mr. McLean. I'm sure that has done justice to the question.
Hello?
Thank you.
There's
so
a hand
much,
from Musa and also from Amel.
I think it's very timely because it's good for people to know. Yes. Thank you very much, sir. Thank you. So we'll be going to the
Hello? Hello?
So we will be calling on Rachel Sikwane to complementation for today. So over to you, Ming.
We struggle to hear you.
Okay,
I'm not sure whether.
Sorry, please, can you hear me now?
Yes, now it's okay.
Can you hear me now? Okay, thank you very much, Mr. McLean, for that, that presentation and also for taking the question. So
Hello?
now we're going to hear from Pauline for her presentation for today. Thank you very much, Rachel. Over to you.
Hello? If somebody is getting me, I think that Juliana has some issue with her line. So we have the last part of the presentation of Rachel, please. Rachel? She has to do a IP commercialization. Thank you.
Thank you. Thanks, Amal. Thanks, Juliana. Amal, will you then just work the slides and just move it to the IP commercialization section? Thank you. Yeah, so afternoon, everybody. Thanks again for being here, and thanks to the speakers that have spoken before me. I am going to be closing off. I spoke at the beginning regarding IP strategy, and I am now going to just speak about IP commercialization and just touch on this topic briefly. It is quite a big topic. I had a quick look on Google to see what it defines IP commercialization as, and it said that it's basically the bringing together of intellectual property rights for them to be exploited so that you can earn profits and grow your business. So there are quite a number of facets that need to be considered, and I will only be touching on a few of them this afternoon. So in commercializing your IP, obviously you would have to start with an IP strategy. And as I mentioned earlier, that is tied to your business strategy. Once you've identified what your business is doing, what your IP will be doing, you would then have to identify your IP and seek to protect it. And we've heard from the speakers this morning and this afternoon around the identification and protection of IP. There are maybe a couple of things that I would add to what one needs to consider when you are identifying your IP. And this slide that is visible now basically just shows that it's important to note that a lot of IP rights in a product coexist. So, when you have, as depicted here, the Nurofen child syrup, you could potentially have a patent in the actual medication, or even in the cap, the lid of the bottle. You would have supplier relationships, so engagements that you have with suppliers that assist you in producing this product that would form part of, your IP. You would have trademarks in the Nurofen brand, licenses. You would have copyright in the, for example, the medical leaflet that sits inside the medication. You'd have design rights in the design of the packaging and the design of the bottle, possibly. Your trade dress, which looks at the look and feel of the product, your customer relationships as opposed to your supplier relationships. All of these would form part of your pool of IP rights that coexist when it comes to this one particular product. And so when you are identifying IP, it's important to note that a lot of times in a product, in a single product, you often have several IP rights that coexist with one another. The other important thing to note when you are looking to identify and protect your IP is that a lot of times, IP tends to impact several areas of your business. So if we can move to the next slide, you'll see that whether you are engaging with your employees, so we had a discussion now about, employees that come up with ideas or innovations, what are their rights vis-a-vis their employer when it comes to those innovations. You are, as a company, engaging with consultants. There are potential IP implications in those relationships and in those agreements. If you have a joint venture, if you have an acquisition or a disposal of an asset or a part of your business, even in your incorporation documents, sometimes one of the shareholders of a company is the one that brings the intellectual property, so to speak, and the other is funding the project. And so one needs to consider what the IP, what the share of IP rights would be, or where the IP will vest. If you have agreements with manufacturers or distributors or licensees. And then also if you have a business rescue or a liquidation situation. A lot of companies now have cordoned onto the fact that you can have your IP held as security in order to gain funding for your business. And so if a company were to go into liquidation, or if that company were to go into liquidation, it would then have to consider what the implications would be on the securitized IP. So it's just to bear in mind then that IP impacts several aspects or facets of a business. And so when you are wanting to identify your IP and then protect your IP, those are the things that you need to bear in mind, both of which then form a critical part of your considerations when you are commercializing your IP. The other thing that I wanted to then speak about, and briefly, is the impact that exchange control and transfer pricing then has on intellectual property matters and the commercialization of IP. So depending on which country you're in, your country may have what's referred to as exchange control regulations, and these would have an effect on transactions where your IP is disposed to a third party or a related party outside of your country. And that may trigger exchange control regulations if your country has them. South Africa certainly has them, and that is something that a lot of our clients have to bear in mind when they're engaging in cross-border transactions. The world has certainly become much smaller, and you find that a lot of companies aren't just doing business in their country, but they're doing business offshore as well, and in certain instances wanting to dispose of IP rights or license IP rights to third parties in other countries. Again, depending on your country, that may trigger exchange control regulations, and it's important to look into that when you are concluding an IP-related transaction with a foreign third party. The other thing to bear in mind is transfer pricing. This is also a tax-related consideration that that you need to bear in mind and would need to seek counsel from an attorney on. Just that the fact that you need to ensure that if you are licensing your IP or assigning or selling your IP, that you are getting a fair value for it. A lot of the tax authorities around the world, excuse me, are looking into transactions, IP-related transactions, to make sure that there aren't any tax leakages or there aren't any undervalued IP transactions that are taking place. And they're doing this, at a large scale and at a small scale. So whenever engaging in IP transactions, particularly with related entities, so if it is a subsidiary in a different country, bear transfer pricing in mind and make sure. I heard McLean mention a few of the models that one uses to value your IP, and there was the IP valuation question that came up. Just make sure that your value that you're attributing to your intellectual property is a fair value, as it may trigger transfer pricing issues if it's found not to be. So that's another two things to bear in mind when you are engaging in IP commercialization matters. And then the last slide is just on the IP due diligence. And this was just a question that I was asked to basically touch on. IP due diligence, obviously, as the name says, it's an investigation or due diligence investigation into an IP target or company. And the points that I've set out there are that basically it helps you to identify and assess and minimize any IP risk, addresses freedom to operate and exclusivity. Just on those first 2 points, obviously when you are acquiring an IP asset, you want to make sure that you'll be able to use that IP asset. Sorry, I see there's a question, but maybe I'll just deal with that at the end. So if we're wanting to acquire an IP asset, you would want to make sure that you're able to use the IP asset once you've acquired it. And due diligence helps you to make sure that you've identified any risks that are attached to that IP asset. I mentioned earlier the fact that a lot of companies have put their IP up as security in order to attract funding. If you were then acquiring that asset, you would want to be aware of any securitization that has been placed on this IP asset that you're acquiring. You would want to make sure that in the case of a patent, freedom to operate, search has been done to ensure that you are actually able to use the patent. Another thing that an IP due diligence would pick up is to confirm that the target company is the owner of the relevant IP and that there is a clear title to use that IP. It also reduces the risk of inaccurate acquisition. You want to make sure that the IP that you're purchasing, that the person you're purchasing it from actually owns it. There was the infamous case not a few years ago, a few decades ago, where Volkswagen wanted to acquire Rolls-Royce. They wanted to acquire Rolls-Royce's trademarks. Well, they wanted to acquire Rolls-Royce's business. And what they did is they entered into a transaction and they basically acquired the whole business that was owned by Rolls-Royce. I think it was Rolls-Royce PLC, maybe. And then only to find out that it was Rolls-Royce Aviation that owned the Rolls-Royce trademark. So they had acquired all these cars, all this equipment, all this machinery, but they hadn't acquired the trademark. That was held in a different entity. And BMW acquired the Rolls-Royce trademark from that entity and subsequently then sold it to Volkswagen for a premium. So you want to make sure that you are purchasing the IP from the actual entity that owns the IP. The due diligence will also allow the acquirer more negotiating room. So if there are any issues that are picked up on, you are then able to use those as a tool to negotiate and either reduce the price or insert certain warranties that would give you comfort. And then just the concluding remark that it would give you deeper insight into the target's liabilities. So those are some of the reasons why one would conduct a due diligence and what one would hope to achieve from conducting an IP due diligence. As I mentioned, these are just a few of the points that I wanted to raise under IP commercialization. I think a lot has already been said by the other speakers just on licensing, assignment, what you can and can't do, copyright, for example. Sarah mentioned a lot on that. And, the negotiation of royalties around that. I think one point that us as attorneys like to make, and yes, obviously we benefit from it, but particularly in IP, it is a specialized field of law, and it is something that you should seek legal advice in. It will save you a lot of trouble and hopefully a lot of money in the long run. So yeah, thank you so much. That is the end of this presentation. Thank you.
Thank you, Rachel. I think that we have one question that we can take right now for you.
So since we do not have auditing standards specifically for IP valuation, how do you deal with these valuations for exchange control regulation for offshore IP transactions? In essence, how do we precisely determine a fair value in light of the lack of these auditing standards? And I think by auditing standards, you're referring specifically to like your accounting standards around determining the value of IP. Okay, so as far as I'm aware, there has been a standard that's been issued. There is an ISO standard that has been issued around the valuation of IP, and there are some companies that have sort of set up to comply with that standard. What I found is that when it comes to valuing IP, lawyers tend to work with accountants because there are accounting principles that need to be borne in mind, but then there are legal and particularly IP legal related issues that need to be borne in mind. I think McLean mentioned that you do have, there's certain IP that is easier to value because it is registered IP, and then there's other IP that you can't actually value. At the end of the day, though, your biggest bet is to go with an unrelated party where you have a willing buyer, willing seller transaction. If your party is willing to offer you X amount of money and they're unrelated, and that's what they determine the market value to be, I can't see a reason why a tax authority would dispute such a transaction. So that's obviously the best bet or the best position to be in. But as was mentioned before, there are valuation methods that are used. It was mentioned the cost method, where you consider the cost that you've put into developing the IP, where you look at your royalty that you could potentially earn from the IP that's being valued. You look at comparable transactions of a similar nature. So even though there isn't necessarily a particular standard, I guess, or threshold that one can use, valuations are conducted, and you can rely on those to value your IP and get some sort of appropriate price. I don't know if that's answered your question. I hope so.
Okay, thank you very much, Rachel. Thank you, Dr. McLean. Thank you, Juliana. Thank you, Mrs. Sarah, for all your contribution at this discussion. Today, we have to note that this was just a guideline when it comes for IP protection into your company. So if you have more questions, related to IP registration in OAPA region, you can get in touch with us directly at this email. If you want to enter into South Africa, feel free to get in touch with us, and we will share our partners, contacts, and the same for Ghana. We cannot continue right now. For the following question, please kindly email us and we'll be pleased to respond. Thank you.
Is at the end, can we exit? Yes. You're on mute. Suppose we can exit.
Okay.